Members, the question is that the motion be agreed to.
Mr. Speaker.
Jacinda Ardern.
Mr. Speaker, I want to begin my final contribution on this bill by acknowledging that the Minister has in the past week, maybe two, engaged with us as an opposition party in the finer drafting details of this bill. I acknowledge that that has indeed happened. But I can tell you that it's a sure sign that something is being done at great pace and with great haste, and unfortunately without the scrutiny that good lawmaking deserves when you are being engaged with, at that degree, so late in the policy development. So yes, I acknowledge that the Minister gave us a call, shared with us various iterations of the bill, but the fact that we were getting amendments the morning this bill came to Parliament demonstrates part of the problem that we have with this process. So, Mr. Speaker, when you rush law, you unfortunately make bad law. You inevitably make mistakes. And I want to debunk some of the myths that have been raised in defence of that process by the government members. They have said, look, we did it in a rush because this was as fast as we could go. We could not have produced this legislation any more quickly than we have, and they've made all sorts of claims about opposition members in the process. I want to debunk some of the myths that have been raised in the House. Myth number one, the statement that somehow we're not allowed to raise process points because deportation is not new. No one has ever said that this is a new issue. Of course, we have had offenders deported back to New Zealand for many, many years, from many, many countries, legitimate citizens. In fact, the Minister's own notes, and no one's ever denied that, Maggie Barry. No one has ever denied that. No one has ever denied that. But Maggie Barry, can I just quote from Minister Adams? Do you want to listen for a moment? Do you want to listen for a moment?
Order.
Do you want to listen?
Order. I'm calling for order, and if the Minister doesn't want to obey that, then she can go somewhere else. I don't care.
I think
and she's carrying on doing that right now. Don't do that.
Thank you, Mr. Chair. I think if the member was willing to listen, I am perfectly happy to follow the facts as set out by the Minister, because we've never disputed them. Yes, in recent years, as it states in the Cabinet paper, in recent years approximately 60 to 100 offenders have been deported to New Zealand each year after serving a prison sentence in an overseas jurisdiction. No one on this side of the House ever denied that. However, recent changes, the paper goes on to acknowledge, recent changes in Australia's visa cancellation policy have resulted in a large increase in the number of offenders being removed or deported to New Zealand. And those numbers are then explained. The rate of deportations has increased from an average about 5 per month in previous years to 25 deportations per month since June 2015. So, yes, Mr. Speaker, deportations have occurred before, but not as we know it now. Not as we know it now. So what about the claim then that was made by the government? Well, at least the government is doing something. Well, Mr. Speaker, that's because they had it within their power. And I'm not just saying that because they have been in government for 7 years. Apparently, we can still be blamed for errors of times gone past, but we're actually in a different environment. Not only has Australia changed their laws in the last year, which means we have this rapid increase, we also have more information available to us. So I'd say to Minister Barry, when Labor was in government, we had no information sharing regime. Australia was not giving us the information that we now, through an information sharing agreement that was only signed in September, we now have the ability to put in a regime like this. In fact, Amy Adams herself said having a regime in place without this information would have been meaningless. So to somehow blame another government for not having done something that the Minister herself claims would have been meaningless without that change in process, I think means that those claims from that side of the House are totally unfair and unjustified. But the argument that the Minister has then made that she has gone as fast as she could, yes, we're not naive, we know how legislation is drafted. You create a regime, then you give your instructions to Parliamentary Council Office. Parliamentary Council Office, who literally write the laws for us, were not told what to write until about 3 weeks ago. This law that we are debating here was drafted 3 weeks ago. Anyone who has read legislation knows it is a complex job. If you don't have time and proper scrutiny, things go wrong. This started 3 weeks ago. Did it have to be that way? No. The Minister herself acknowledged that she knew that we had a problem. Well, if she read the paper, she would have known well over a year ago. The Australians said, hey, New Zealand, we're changing our laws. You should know about that a year ago. And the Minister claims that she's been working on it since then. Really? Really? It does not take a year to give drafting instructions to Parliamentary Council Office. And in fact, as far as I can tell, some of the Cabinet papers on this, which is the first step in the process, some of the papers that went to the Cabinet saying this is what we should do, well, that happened well after August. We know there was at least 6 months where nothing appears to have been happening. And in that time, hundreds of offenders were being packed up and shipped out. So yes, we have a problem with the timeline for this bill. We have a problem with it. And our concern is that as a result, we will have made bad law. And what signs do we have that that might be the case? Well, let's look at the way that the law is going to work. The law has set out that there will be 3 sets of different kind of offenders coming back into New Zealand. 3 types of returnees. We would add the first category being those who shouldn't be deported back in the first place. As the Minister said, we're not just talking about offenders who are being sent back to New Zealand. There's a character test, which is the cause of about 40% of the people being deported back into New Zealand are failing a character test. These are people who believe themselves to be Australians who are being deported to New Zealand, a place they have no connection to simply because they may have been born here or had New Zealand parents. And on a character test, they're being sent back. We think that's wrong. We'll continue to fight that. And I acknowledge again the enormous amount of work that Kelvin Davis has done on that because our Prime Minister hasn't. The second group of people who are being deported here and are covered by this regime are what we call returning prisoners. Returning prisoners are those who are defined as having been released for having served a sentence for an offence that attracted a sentence of a year or more. They're being released and they haven't spent 6 months out in the community. Now, the rationale of the Minister is if they haven't spent 6 months out there, we don't know if they're able to reintegrate properly. So those ones, that group of deportees, when they come back into New Zealand, they will automatically be monitored, automatically. The point here is that you'll notice that we're not focusing on the offence of the person being deported. It doesn't matter whether or not they've committed a highly violent crime or whether they've stolen something from the back seat of a car. That's not what New Zealand in this regime is paying attention to. It's simply whether or not they've been in the community for 6 months. Now, that in itself has some issues attached to it. And then the next category of people are those who have been out in the community for 6 months before they've been picked up by officials and sent back to New Zealand. That category of people, for them to be monitored, New Zealand's corrections service has to apply to a court. Now, those individuals could be murderers, and we know that some of them are. They could have been child sex offenders, and we know some of them are. They will only be covered by a regime if corrections goes through the courts. Now, our concern with that is we already, since December of 2014, have had the ability to monitor serious offenders who are deported to New Zealand if corrections asks for them to be. How many have they asked to be monitored in a year? 0. Not one. 30% of people who have been deported back to New Zealand in the last 2 years are categorised as serious offenders. Corrections have applied for not one of them to be monitored. We are concerned that this bill is reliant on a department that is underfunded, under-resourced and managed poorly at present, and we are giving them an enormous job. Mr. Speaker, in summary, this bill has been rushed unnecessarily, it hasn't been given due consideration, and yes, while we agree we need a regime, we argued that we should have had another bill go through a full process to replace this one. It's disappointing that we're here in this House doing this at the last minute because New Zealanders' safety is reliant on us doing a much better job than this.
I call the Honourable Sam Lotu-Luinga.
Thank you, Mr. Speaker. Mr. Speaker, I rise